Child support and 50-50 custody in Illinois. Parents know that the parent who spends most time with a child is typically awarded child support, but when custody is split equally, the calculation is less obvious. Illinois law grants courts power to order one or both parents to pay a reasonable support amount. Child support is determined by calculating each parent's net monthly income and combining those incomes, choosing a basic support amount from the schedule of obligations based on combined income and number of children, and then allocating each parent's percentage share. The receiving parent's share is presumed spent directly on the child. When each parent has at least 146 overnights, the basic support obligation is multiplied by 1.5. Each parent's portion is multiplied by the percentage of time the child spends with the other parent, and the smaller figure is subtracted from the larger. Parenting time is determined by the child's best interests, not by a parent's financial motives. An example shows how the formula works. Jim and Laura earn $50,000 and $30,000 net per year, giving them a combined monthly net income of about $6,666. The state schedule lists a $1,091 monthly child support obligation. Because they have more than 146 overnights, that amount is multiplied by 1.5 to $1,636.50. Jim's share, based on his 62.5% share of the combined income, is $1,022.81. Laura's is $613.50. Each amount is multiplied by the percentage of time the child is with the other parent, producing obligations of $511.40 and $306.75. The difference, $204.65, would be paid by Jim, even though they share the child equally. This illustrates that equal parenting time does not eliminate child support when incomes differ. Courts must apply the guidelines or justify deviations in writing. Deviations are allowed only if applying the guidelines would be inequitable or inappropriate, and the court must specify reasons such as extraordinary medical expenses or special needs. Without written findings, child support cannot be reduced to zero. Judges also consider the financial resources and needs of the child and parents, the standard of living the child would have enjoyed had the marriage continued, and the child's physical, emotional, and educational needs. Where one parent's income far exceeds the other's, the guideline amount might be adjusted to prevent a dramatic disparity in the child's lifestyle between homes. Illinois law directs courts to examine whether deviations are appropriate, and the state's high court has held that a custodial parent may even be ordered to pay support to a non-custodial parent when the facts and the child's best interests warrant it. Shared custody arrangements still require both parents to support their child. Additional costs like childcare, health expenses, and extracurricular activities can be allocated according to each parent's share of income. Parents seeking equal custody should remember that judges do not award parenting time based on attempts to lower child support, and a knowledgeable lawyer can explain the best interest standard. If you're considering a 50-50 parenting schedule and want to understand how child support will be calculated, consult an experienced attorney. A Chicago divorce lawyer can help you navigate the guidelines and determine whether a deviation might apply. The law office of Russell D. Knight, a family law firm in Chicago, assists parents with shared custody and support matters. Contact the law firm at 773-334-6311 or visit 1165 North Clark Street No. 700, Chicago, Illinois, 60610, to speak with an attorney about your situation.